Greetings from Australia to Secretary-General Bernasconi, our friends and colleagues of the Hague Conference, and to all of you who join us today to celebrate and reflect on the 25th anniversary of the 1996 Child Protection Convention. The Australian National Anthem used to contain the lines, "Australians, let us all rejoice, for we are young and free." The anthem has officially been amended to "For we are one and free," to acknowledge the multicultural nature of modern Australian society. As for the young part, that was only ever true if Australian society was deemed to date from the first days of the European conquest in 1788. In point of fact, our nation's first people, the Australian Aborigines, have lived on the continent of Australia for some 60,000 years. This depiction is located on the wall of a natural rock formation which has sheltered perhaps hundreds of generations of people who lived in what is now a semi-arid region of northern Australia. Scholars have suggested that the figures you see on the screen are the members of a family, or to be more accurate, depictions of the spirits of those people who used to shelter there about 45,000 years ago. This presentation represents my views, and I gratefully acknowledge the assistance of Georgia Bishop, Legal Associate. Australia acceded to the 1996 Child Protection Convention on the 1st of August 2003. The convention is currently in force between Australia and 52 contracting states. The convention has been signed but is not yet entered into force for the United States of America, North Macedonia, Canada and Argentina. In Australia, our most common requests are Article 23 recognition requests, followed by Article 33 placement requests. Our most frequently encountered partner country is the United Kingdom. The Children's Conventions would not operate without central authorities. We have an Australian Central Authority and a Central Authority designated for each state and territory in Australia. The state central authorities are routinely the government departments charged with the welfare and protection of vulnerable children for the state. Our Australian Central Authority is the Federal Attorney-General's Department and comprises 6 lawyers and 2 or 3 non-legal case officers. There is a strong and respectful relationship between the Hague Network judges, who I will discuss in detail later, and the Australian Central Authority. I thank the Central Authority for the information it's volunteered for this presentation. Within the 1996 Convention, there are easy lines of communication and cooperation between states for which the Convention has entered into force. The Australian Central Authority also receives requests for assistance about non-convention countries. In those cases, our Central Authority will try to seek assistance from the other jurisdiction's Central Authority appointed for the 1980 Convention, if that jurisdiction is a member of that convention. That other Central Authority might, for example, identify and provide contact details for the child protection authorities in the appropriate region of that country. This kind of cooperation is in the spirit of the 1996 Convention and possible because of the strong network which has developed between the central authorities and which the co-directors of the Australian Central Authority are very keen to maintain and nurture. Article 33 is most frequently encountered by Australia and is engaged when a child is going to be sent to live in Australia. It is designed to ensure that the child's arrival and proposed new place of residence in Australia is safe. The 2 main issues that the Australian Central Authority experiences with Article 33 requests for cooperation are the lack of anyone confirming that the child is in fact eligible for an appropriate visa, and the lack of meaningful and timely engagement in the Article 33 process. In some cases, our Central Authority has found that a child's visa hasn't been applied for and that the placement is derailed because the child is not eligible for a visa. Our state and central authorities are extremely helpful and hands-on in the management of an assessment of the family into which a child is to be placed. This is a helpful consequence of the state central authorities being the child welfare agencies for each state. State central authorities are very much focused on making sure that any proposed placement in our jurisdiction will be in the child's best interests. One of the more complex Article 33 requests involved a placement of a child where the overseas court was about to issue a final order permanently placing the child into the care of an Australian family, and at that point the Australian Central Authority became involved. The child was being placed with an extended family member and their family, but they had never met. They had Skyped a few times. The Australian Central Authority found that not only had no one considered the child's eligibility for a visa, but the child had no passport and no ability to obtain a passport for a wide range of reasons. The child was also going to have to move from a large European city to a very regional and remote area of Australia. It was always going to be a massive adjustment for the child. The Australian Central Authority asked that the relevant overseas authority to consider seeking only interim orders rather than a final order, and to also include a Plan B contingency in their planning for the child to ensure that alternative arrangements were in place if the placement didn't work out. The court did so. Sadly, the child and the family failed to adjust to one another, and Plan B became necessary, and the child returned to out-of-home care in the other jurisdiction. The next most common provision in the 1996 Convention for Australia is the recognition and enforcement of measures as provided for in Articles 26 and 23. Prior to the 1996 Convention entering into force, the recognition of orders between Australia, which is a common law jurisdiction, and other countries was problematic and quite out of touch with the realities of families living across international borders. Regulation 23 provides that orders from contracting states will be recognised by operation of law, that is, without the need for a legal process, in other contracting states, subject to refusal on limited natural justice or procedural fairness and public policy grounds. Article 23 means that an order made in Switzerland is recognised as an order made in Sydney. Now, recognition is not enforceability. Recognition will render an action lawful but not enforceable. In most instances, cross-border families require enforceable orders or enforceable measures. The key to the success of the enforcement provisions is the simple and rapid registration process required under the Convention. Regulation 12 of our Family Law, Child Protection Convention Regulations 2003, has been effective for Australia. Each large family court registry has a registrar who is responsible for effecting recognition or referring it to a judge for immediate attention if something is amiss. Where the Convention falls down in its operation is when contracting states fail to or neglect to adopt a simple and rapid registration process for the enforcement of orders from other jurisdictions. Article 24 provides for advance recognition. Australia has had little experience with advance recognition, perhaps because in the wording of the article it's fairly cumbersome to enforce. We would need to make a final order before we could send it overseas to have it recognised and rendered enforceable, whilst retaining sufficient jurisdiction to revoke the process in the event that enforcement was not achievable in the other jurisdiction. We have had other cases that have needed us to help parents navigate rather less common aspects of the Convention, such as parental responsibility. In one case, a mother had sole parental responsibility for her child by operation of law in another jurisdiction, Germany. In that jurisdiction, an unmarried parent only secured parental responsibility for the child if they took positive action to claim that responsibility. The father in that case had not done so, so the mother retained sole parental responsibility and she moved with the child to Australia. The mother wanted to take the child from Australia to an overseas destination to see her family, but the authorities in Germany refused to issue a passport for the child because the mother could not prove that, as a matter of Australian law, she had sole parental responsibility. The child had by that stage been in Australia long enough to have changed his habitual residence to Australia. In Australia, according to our law, a parent automatically has parental responsibility until a court orders otherwise. So, because of Article 16, Subarticle 4, the German father had parental responsibility according to Australian law. In the end, the mother instituted proceedings in Australia for sole parental responsibility for the child, which she obtained. If we take this case a little further than it actually went, it could be a good example of the saying that under the 1996 Convention, you can add but not subtract parental responsibility. By this I mean, in Germany, the child had one parent with sole parental responsibility. Upon assuming habitual residence in Australia, both parents had parental responsibility. If the child then became habitually resident in Germany again, Article 16.3 would mean that the father in Germany would continue to have parental responsibility under German law. He could also exercise that parental responsibility in Germany because German law contemplates two parents having parental responsibility. However, what if the child went to from Australia to a one-parent custody jurisdiction like Japan, which by the way is not a party to the 1996 Convention, but I'll use it simply as an example. If the child then acquired habitual residence in Japan, the German father would still retain parental responsibility in Japan, but he would not be able to exercise it in Japan because Japan does not recognise the exercise of parental responsibility by more than one parent. That's the basis of the saying, you can add but you can't subtract. Chapter 3 of the Convention deals with applicable law. Article 15 provides that authorities may exceptionally apply or take into consideration the law of another state with which the situation has a substantial connection. I have recently had argued before me a case in which it is likely that a request may be made by an Australian court of the courts in the Netherlands to consider applying some of the Australian law to the resolution of a family law case in the Netherlands, because Australian law would have a greater emphasis than the law of the state of habitual residency could possibly have in relation to the importance of the child's Indigenous heritage, that is, the Aboriginal heritage. The Australian Central Authority is grateful for the information and sharing of experience from its European colleagues because of Europe's vast experience in dealing with both the 1996 Convention and the Brussels regulation cases. The Central Authority network is like an international brains trust. The Australian Central Authority received a request in one matter from a European nation for assistance that appeared to relate to a succession matter which is expressly excluded under Article 4 of the 1996 Convention. But it emerged that the assistance that they were seeking related to the appointment of a guardian ad litem for the children and not a succession matter. The Overseas Authority was very helpful and forwarded our Central Authority decisions from the European Court of Human Rights relating to similar cases to explain the basis of the request. Of course, there are the provisions in the 1996 Convention for the provision of information. In one case, the Australian Central Authority was notified of a child who was alone in a large European city. The child, aged 15, had gone to visit her mother for a contact visit, but their relationship had broken down and the child had left the mother's home. The child's carer in Australia raised the alarm, fearing for the child's welfare. In that case, the Australian Central Authority was able to submit an urgent request for the other jurisdiction to consider taking measures in respect of the child and detailing its concerns under Article 32. The Overseas Authority sought police and child protection assistance and were able to quickly locate the child. The Child Protection Authorities ensured that the child was ready to safely travel and be cared for until they were placed on a flight back to Australia. Article 9 under the 1996 Convention provides for a contracting state, as referred to in Article 8.2, to request jurisdiction to decide a particular case if they believe that to do so will advance the child's best interests. In 2020, the Family Court of Australia determined that it was better placed than a Norwegian court to assess the best interests of an Aboriginal child found to be habitually resident in Norway. Orders were made for a request to be made of a Norway court for Australia to assume jurisdiction in respect of a child pursuant to Article 9. All of the technical requirements of Article 9 and 8 had been met. The basis of the request was that our court considered that it was better equipped than the Norwegian courts to take into account the profound relationship between Aboriginal people and their lands, as had been referred to by a recent decision of our apex court, the High Court. This slide illustrates the very strong sentiments expressed by our apex court in relation to the importance of Aboriginality. We understand from the Norwegian Central Authority that the matter is finalised on the basis that Australia's request to assume jurisdiction was not accepted. Chapter 2 of the 1996 Convention deals with jurisdictional rules. This is a particularly important and frequently encountered provision. In relation to children who are the subject of proceedings or potential proceedings under the 1980 Convention, there is also Article 7 of the 1996 Convention, which provides for a child who is wrongfully removed or retained to not lose their habitual residence except under certain situations. I have a case at the moment pending with the Ukraine in which the child, on my interpretation, is still clearly resident in Australia, and Australia is the correct forum pursuant to Article 5. It's a work in progress. I invite you to go to the Hague website and look at the information on the International Network of Judges. The network is only as good as the number of countries we have with effective network members. Under the 1980 Convention, it's clear what law is to be applied. On the other hand, under the 1996 Convention, its operation often is unheralded. The practitioners and the judges who encounter the 1996 Convention are frequently uneducated or uninformed about its operation. It is particularly helpful to have the assistance of a Hague Network judge within one's jurisdiction when looking at the implications of the 1996 Convention. In Australia, our Hague Network judges are the Chief Justice of the Federal Circuit and Family Court of Australia, who is also the head of family law jurisdiction in Australia, my colleague Justice Gillian Williams, and myself. A shortcoming for Australia is that our immediate neighbours do not number highly in the International Hague Network of Judges designations. Australia encourages designations by all countries to the International Hague Network of Judges. The country does not have to be a contracting state to either convention in order to make a designation to the network. They just have to be willing to enter into a discourse between a designated judge in their country and designated judges in other countries in accordance with the prescribed and firm protocols that exist for the operation of the network. Judges in contracting states and even non-contracting states have very similar functions within their own jurisdictions. We are all in it together. If anyone has queries about how to advance the designation of a judge for a particular jurisdiction, I encourage you to contact the Permanent Bureau. If you want to speak to someone personally who is a network judge, I'm happy to speak to you and my details follow. The fact is that the judges from contracting and non-contracting states all perform very similar functions. We are all alike. Our strength is that we can obtain benefits from each other by sharing the information and sharing our practices and doing safely within the secure confines of an organisation like the International Hague Network of Judges. That concludes my presentation. Thank you very much.